that's one thing I got you back over here for. Another thing that I have on my list is the edited victims' statements.
Yes.
Do you have those?
We, I don't have them right here with me, but we do have them, and we looked at the order you had, and I believe you actually ordered that more be redacted than was in the order. So we prepared the order according to what our notes indicated, not only what you had in the order, but what our notes indicated should also be redacted or changed. And so, so we have those and can submit those to the court.
Okay.
But, if that's what you're looking to do.
That's what I'm looking to do.
Submit those to the defendant, sure.
Yes.
We can do that as well. So, so those are prepared. We've gone through those. I believe they've been changed in accordance with the hearing we had to follow those instructions, not only based on the order, but based on what our memory of the notes were, that I believe had a little bit more changed or redacted than so I believe we had that.
The other purpose is to identify if there are any other motions that need to be dealt with between now and the beginning of penalty phase.
Judge, I think motion at this point, we have not, of course, received any discovery from the defendant concerning any evidence that he may present, and he's required to do that now at this time. He is not required to produce witnesses of this beforehand in regard to that. I know he's already provided some witnesses that may constitute some of the mitigation matters. But any other matters he would, if there are other folks listed as experts, I think reports of those experts and those kind of things, I think so. There is a good bit of discovery that we would expect that we have not received that we would need in preparation for the sentencing phase of this part of the case. We have not got.
And specifically, that is any experts and any other witnesses?
Any other witnesses that aren't otherwise included on his witness list, statute, but I don't think he was required, as far as witnesses for sentencing, to do that until after the verdict. And at that time, he'd be required to do that. And so I think we have not only the names of those witnesses that weren't otherwise included, but also any reports, I believe, of any experts or anything like that. I think if the investigator has written statements, I think we'd probably be entitled to those as well. So we have that. And you also have the matters that we've been hearing about in regards to the matter of opportunity as well as the armed robbery. But the discovery is the first matter.
Okay. You want to respond to that?
Yeah, Judge, kind of, you know, as far as that, that's what we in the process of doing. Tighten up the loose ends on that. I think I might have if to do with just a couple of them. I talked to a litigation lady about that. I really don't think it's too much. As far as Timothy Hood, I gave him that in the reciprocal discovery levels. He got the whole Timothy Hood thing. He know better than me. He got all the videos and he know more about my brother case than I do.
Well, let's take it one at a time. How about their request to disclose any experts that you've identified, including their reports that you plan to put in evidence in this next phase?
Well, I gave it to him, Dr. Derek Gunn, and they already have them anyway. There was a court-appointed expert, and they already have, and I gave it to him the evidence for the civil discovery. So he already have it. As for Dr. Derek Gunn, they've been on the list. If I add somebody new to the list, I think I might have one or two people, if that, or just a couple of people. And I also like to make a motion limited to exclude future danger evidence and argument. It is my understanding that the state intends to present evidence to establish the aggravating factor of future dangerousness, and thereafter to argue to the jury that I should be executed in part because I would be a future danger is sentenced to life in prison. Under the federal constitution, an accused may not be sentenced to death based on information which he had no opportunity to explain or deny. in Skipper versus South Carolina, the Supreme Court said that where the prosecution specifically relies upon prediction of future dangerousness in asking for the death penalty, it is the elemental due process requirement that a defendant not be sentenced to death on the basis of information where he had no opportunity to explain or deny. Skipper cited Gardner versus Florida, Florida, 430 U.S. 349, 362, 1977, in support of that proposition. My request for funding for a future danger expert was denied by this court, and I therefore have been denied my constitutional right to explain or deny such prosecution evidence and argument. Wherefore, I move to exclude this evidence and argument from the penalty phase without failing my further objection to the denial of my requested expert for purpose of establishing affirmative mitigation evidence of lack of future dangerousness. No, he want to use all this future dangerousness. What his specific discovery? Let me see who he got. I don't know who he called in the litigation. You know, they're going to bet on that, young. And the litigation guy, what we have, George McKeon, they want to introduce this illegal armed robbery conviction on me, but the so-called victim, we can't reach him. He's somewhere in Colorado or something, or something. And I want him back here, so there's some things in this transcript and some things that happened that nobody didn't want to talk about for years, but I can get him and cross-examine him on that. And I think they had him on the witness list, George McKeon, as an aggravated witness. So they say he's somewhere in Colorado and can't be reached. And we really need that guy here.
What's his last name?
McKeon, I guess how you spell his name, George McKeon. McKeon, something. McKeon. It's back in the show. What is McKean or something? McKeon, something.
Who is this?
This is the alleged victim of when I went to prison for the armed robbery. And I really want him back, I really want him back here too. I don't know who his mitigation people is or what he got, what aggravated he got, so how could I rebut what he got? He never gave it to me.
Let's take this one at a time.
Okay.
First of all, you telling me that you disclosed whatever evidence of experts
Yeah.
that you plan to call, is that right?
Yes, sir. I've been done that.
And you said there may be some more witnesses, but when would you know that?
We'll know that tomorrow. It ain't many, Judge. If any, maybe 1, 2, or 3, it ain't a lot of them.
I'm going to order that information be provided to them no later than 11 a.m. tomorrow morning. Okay?
Yes, sir. And I also like to state for the record while Mr. Malden is here, this is for the record. You know, the officer took my pen while the jury was in the box before the verdict was read. This was in full view of the jury. And in fact, someone watched the live feed, tweeted about it. They made a tweet about an officer. I ain't necessarily calling the officer's name, I'm not here for no name, but somebody tweeted to somebody on the legal team saying, look, we seen they making tweets about an officer took his pen in full view of the jury. And the legal team felt like that was bias and prejudice because, well, he's so dangerous, we got to take the pen from him. And the massive showing of uniformed officer presence just gathered around me, it never happened. We got officers just all of a sudden just go around me, and we had a massive amount of officers doing it in the courtroom. See, that sent a subconscious bias. This man's so dangerous, we got surrounding them, and it ain't been doing it. I haven't made no officers, I haven't threatened nobody. You know, they just found me guilty of murder, so they might feel like he's so dangerous, they got to be all around him because he's going to do something stupid or crazy, he's going to hurt somebody. And then I think it was a couple of officers around the jury. I mean, why it ain't been 3 or 4 officers around the jury, why they got to do it now? It made me look like I'm going to do something stupid or crazy. So I did like to state for the record that was very prejudicial and biased because, you know, we finna go to the citizen phase. This man's so dangerous, they got to now surround him. Because he finna do something, finna hurt somebody. Therefore, everybody would invoke somebody to give me the death sentence, then because subconsciously. So, you know, I'm not here to call nobody name, I just want to state that for the record.
And let me ask you again on this discovery, are there any written reports that you plan that have been prepared by any of your experts that would be discoverable?
Well, other than
Like say,
what we've been having for years, it's the same thing.
and you've already given that?
They gave it to them.
Okay, that's fine. So the only thing left outstanding in discovery will be identifying any additional witnesses no later than 11 a.m. tomorrow morning.
Okay, well, she identified it to me. Did she email them, the attorney, the district attorney, how did that happen?
She can, is there any objection to her emailing that to you? But of course, it would need to be the names, address, and contact
Who
information.
would do that?
Would that be Ms. Sullivan?
Yes. Litigation specialist.
Do you have any
I
problem
certainly don't have any
receiving?
problem with that, no.
Okay.
Judge, can he do the same thing, if he give me his litigation witnesses? Because I don't know who he got on there. He got about 30 Barrow County officers, and I need to know who he gonna call and who he ain't gonna call. I don't have no reciprocal discovery from this guy on litigation, not nothing other than the victim impact. Not that I know of, he told me that he's gonna use. So I got to know what he's doing in order for me to prepare, but the same thing he telling me.
Mr. Ball?
Judge, well, first of all, I don't know, Dr. Debbie Gunning was one of the witnesses, one of the folks who did a evaluation for competency back, before Your Honor got the case, it was before the person recused was decided. It was decided by Judge Sweat, so I'm not certain why she was testifying or what she was doing along those lines. But apparently that's, I assume that's the report that you're talking about, some report that she may have done. Of course, I thought Karen Bailey Smith was the one who testified also during that hearing. She's kind of head of all that forensic matter like that. But those were incompetency. Folks who talked about that, who talked about saying he was not incompetent and everything else. So I'm not certain what he's going to be presenting along those lines. But as I understand, what other witnesses they intend to get to is they intend to get that by 11 tomorrow, as well as any reports, if there happen to be any outstanding reports. Is that?
That's what I'm saying.
Okay.
I think he's asking about your witnesses.
We basically served him with the folks that we expect to call already, as well as any reports from that. And they have done that well in advance of trial. And those witnesses, if there are additional folks, we'll certainly provide that by 11 o'clock tomorrow, if there had to be additional people that we need to call. But we basically provided him with the list of witnesses, and folks have been included on that witness list for some time, as well as any reports or anything else that we may choose to present along those matters, in addition to the victim impact testimony. So we've done that. And address the future dangerousness matter. That's, so it's not a matter of basically saying we need to basically indicate to them right now, these are the ones we're going to call in the order we intend to call them, and that's not, I don't think that's how it works.
He's not required to do that.
Okay.
Just as you're not.
Okay.
Let me ask this before we go any further. In order to facilitate this exchange of information, can we ask that Ms. Sullivan and Mr. Malden exchange their email addresses, and so that they can have that exchange of information? Do you have any objection to that? Because I'm afraid it won't get to you.
Exactly, I have no objection to that.
All right. They can do that between themselves after we finish this then. Now, do you want to be heard on the future? I'll hear you again, right?
Sure.
I want to take this one at a time if I can. The future dangerousness issue.
Well, yes, just to go back on that, but we'll address it more if need be. I assume Ms. Sullivan is not going to be testifying or anything like that. So, in regard to the future dangerousness, Judge, there are a number of cases that set out that the state is permitted to do that in the favor of trial particularly permitted based on the evidence, and I think there's already been evidence from which inferences can be drawn about the future dangerousness of the defendant, and I expect there to be further evidence that will be presented, considering that. So at that time, I don't think there's a reflection. I can give you a number of different cases. Hill versus State, 263 Georgia, page 37, 1993 case. Henry versus State, 278 Georgia, 617, and 2004 case. Westford versus State, 289 Georgia, page 70, and 2011 case. McLean versus State, 267 Georgia, page 378, and 96 case. Mason versus State, 274 Georgia, page 79, 2001 case. Cited Sterling versus State at 267 Georgia, page 209. Fulton versus State at 278 Georgia, page 58. Or is Harrison versus State. At 257 Georgia, page 528, 1987 case. And Spencer versus State at 260 Georgia, page 640, 1990. In addition, we have Ross versus State at 254 Georgia, page 22. Walker at 254 Georgia, page 149. Brooks versus Kemp at 762 Federal Section 1383, 11th Circuit case, 1985. Darden versus Wainwright at 477 U.S. page 168, 1986 case. So there are a number of cases, I think, the prevailing authority is that argument is certainly permitted, and will be permitted in this case. I believe there's already evidence of that that's come out, and I believe there's further evidence in the sentencing about that matter.
Yeah, I want to call Aileen Bishop Howard. They using Tony Howard and Shalisa Howard for a victim. I'm supposed to be able to rebut that. The stuff that the jury didn't hear, I plan on playing that whole tape. So the jury can hear some stuff they did hear. So that'll take some of that malice off me too. See, by them not hearing the whole entire tape, they'll get laid, the jury on what really happened there. So, and for a mitigation, I like to bring her in and we play the whole entire tape so they can see another part that they can't see. And rebutting Officer Howard, Shalisa Howard.
I'm not here to take up all of that sort of thing. I'll just have to take it up when it comes. But I don't.
Yeah, I just want to let him know he was.
But if you're disclosing that, then that's who somebody you plan to call.
Exactly. She was already on the witness list, and I had planned on using her both faces if necessary. So she was already on the witness list. He already knew what was going on. The stuff that the jury didn't hear, as far as whatever reason in court, as far as the guilt is, this is a whole different phase. And so I would say the things that I couldn't say, I'll be allowed to say it because I'm rebutting the victim impact statements that he had. And maybe the jury see all the evidence and they can even look at me in a different light.
All right.
So I plan on doing that. So let him know before he get there, before he jump up and start objection, this is a whole different scheme as for the defendants. And I'm using it as a rebuttal to Shalisa Howard victim impact and Tony Howard victim impact. So I intend on doing that.
What other matters we need to take up regarding the Timothy Hood matter?
Okay. Well, he already got the civil discovery. He been had the case he know before me. He looked at the video for years. So it's time to bring it to the light that it's not guilt innocent phase. This is the mitigation phase, which played a significant role in his police shooting incident. So this ain't nothing new to him, Judge. He been having civil discovery before you become a judge. So I gave it to him in a civil discovery, and I plan on introducing what I gave to him out of it with civil discovery.
You had not ruled on this admissibility of that when we opened in 97 on robbery, or late 90s on robbery. And I don't know what he intends to do about that. He talked about it, but I don't know whether you ruled on that. I think you left that for this stage. So,
Can I speak on that? Okay, Judge, he intend on using that as an aggravator, so it's my right to rebut that. And and I think it's a Ron Pillar case saying that for the mitigation phase, I can bring in a record of even witnesses. It's totally relevant because these are events that happened in my life that ultimately led me to facing these charges, put my life on this path. And again, the record don't lie, never will lie. So I intend on talking from the record and questioning them off the record. Not nothing new. We just keep it as far as the record. And we'll just, I'm pretty sure if I do something online, you object, but you will sustain the objection. We'll handle it like that.
Let me touch on this person that I still haven't heard the exact name for this, the alleged victim in that, no, not the Timothy Hood, in your case, in your armed robbery case. I mean, if he's not here, and unless you're telling me that y'all have got him coming here.
We don't have him coming here, Judge, because I understood he's in Mexico. That's what I've been told. I don't have any idea. I think he was, I have not communicated with him. Apparently, if he got a call from their investigator, he's letting us know about that and doing that. But I think, as I understood, it was left of, Legion would call you. So I hadn't heard anything about the contact with the investigator and everything else. But what the circumstance is, or him testifying or not testifying, I will tell you on that armed robbery, I think at this stage, you could probably go into that, but I know you had not ruled on that. But at this stage, I think you could. I think in regard to Timothy Hood, you could too. But I just wanted to make sure that we were on the same page about that, and that's what I wanted to deal with. But
Judge, you also recall he had this guy do a mitigation. He attempted to have this guy do an aggravator statement on me, victim impact statement on me, and you excluded that for that May 27th. So he was intending to use this guy, and I think this guy running because for years I've been waiting on him, and I finally got him. Doing trial the first time, we had a lineup, he just skipped the lineup. Like now, he all of a sudden in Mexico.
You served a subpoena?
Yeah, we've been done it. He's been on the witness list for a long time.
Have you subpoenaed him?
Yes, they have. Have they done it? Yeah, they've been done it. And this guy skipping town again. That's why I've been waiting on him for years. So
we can, frankly, we can try to make contact with him and see what the circumstances are as far as.
said somebody in Colorado. I'm sorry, I cut him. I'm sorry. Well,
I didn't hear anything about him being in Colorado,
Yeah,
but I understood it was, that last I heard is he called and said he was in Mexico and doing that. But we'll make whatever efforts we can to get him back, if that's, you to do that, we'll certainly make sure of that. But, the witness leave is kind of like Rashawn Allen not being here, in that regard, but, in honoring the subpoena. As far as, and I don't know anything about the cost or whatever it is, I don't have any idea, but we'll certainly make an effort to try to contact him, but, I just not one that, about him coming in. But this is what I was going to say. I think we initially had a statement from him during the hearing about victim impact, and withdrew that and understood that was not going to be victim because he wasn't a victim in this case. So that's what happened, and he said that may very well be something you might present in the aggravation part of it, but that was no guarantee that we would do that at that time. Frankly, him being back, I don't think would be a negative thing.
well, he told my investigator something like he was being a firefighter in Colorado or something. Now he just said Mexico. In my position, he's trying to run for what he's done, and he don't want to face what's going on. And by God, I've been waiting on him for years, and I really want to be a judge.
Well, I can't address that because I don't know.
I can't do nothing to tell you.
How was he subpoenaed in Colorado?
I don't know. My investigator went to the house and subpoenaed before this. I wouldn't want to think it was here. He subpoenaed him somewhere. That's what they told me. I don't know. I've been going to jail for the longest, but I couldn't tell you.
Well,
But I called him and asked him. And I see when I get back with you on that, and let you know what's going on with it.
We'll make effort to contact him, Judge. I don't think he's moved to Mexico, I think he's there on a trip. I think he's what the story was, but other than that.
I think my investigator, he told them something like the 20th or something, he'll be back, something, I don't know, I just call him and ask him. I don't wanna tell you that I'm not sure.
What else? Anything else we need to check up? We'll talk. It sounds like that both the state and the defendant understand that there can be evidence regarding the Hood incident and the armed robbery conviction of the defendant. So some of that will come in. There may be objections to certain parts that I don't know until I hear them. Generally, that information comes in. I do want to point out that the defendant will have the option of his opening statement directly after the state, or it can be after the state's evidence. So when the time comes, I'll be looking. I'll ask you if you're ready for your opening statement on this. Makes sense.
And, of course, there can be rebuttal as well.
Rebuttal evidence?
Yes.
Okay.
I don't know what it will be, but there will be.
Anything else we need to take up? Because I'm thinking that we've all got things we can now do tomorrow. I'm trying to avoid gathering y'all back together for anything tomorrow. By the same token, I plan to start at 8:30 Wednesday morning, and if there is an issue, I am going to gather you back together tomorrow if it's something we need to do.
I know the one matter, Judge, I think we had looked at possible charge, and I think the pattern charge is probably the one to go with. I know in some of the ones, the cases that we've worked through in preparation for this, where there is an opening charge for the jury, you intend to give one to the jury prior to opening statements, and then, of course, there's a charge at the end. So if you have a proposed charge, Judge, that would be
You'll get,
very
if
helpful.
I have one.
If you have one, now we may have a draft based on the pattern that we could possibly email if we have that.
If you want to get
Jake,
that.
you worked on that, I just didn't know whether y'all had looked at that and had a proposed charge.
I haven't
But I
prepared
think there
one.
may be one for the, prior to opening statements, prior to the beginning of the sentencing phase, and then one at the end, of course. So that might be a possibility.
If you have one, I'll be glad to look at it. I just haven't had time to do it.
Sure, that's fine.
And I guess that would be, if you send it to me, I would say, obviously, you need to send it to them and maybe
Right.
add Ms. Sullivan to that
That'd be
list.
fine.
too.
Sure.
So,
That'd be fine, I can send it by email to Ms. Herbert and Mr. Hamilton and Ms. Sullivan, I'll do that.
I hope you don't got to call up in tomorrow, do you? I want this whole day off tomorrow. If you don't have to
that's
call.
exactly why I'm keeping y'all here tonight, trying to get all this done. So that everybody has a full day to prepare. That's what I'm trying to accomplish. I will say for the record that I have reviewed Part 3 of the Unified Appeals Procedure. I don't see anything here that needs to be addressed at this point. It looks like it's all things that we have done. For the record, I have done that. All right. Anything else?
No, thank you.
All right. Mr. 188, and I'm gonna just get word to the jurors that we are taking up the